The wheels of justice often turn on intricate procedural points. A recent ruling from the High Court of Jammu and Kashmir and Ladakh has brought one such crucial aspect into sharp focus. This decision, delivered in May 2025, concerns the deferral of cross-examination of prosecution witnesses. The court clarified how trial courts should approach requests to postpone questioning witnesses. This ensures the accused receives a fair chance to present their defense. At the core is Section 254, subsection 3 of the Bharatiya Nagarik Suraksha Sanhita 2023. This section is the successor to Section 231, subsection 2 of the older Code of Criminal Procedure. It grants judicial discretion to trial courts. This discretion allows them to defer the cross-examination of a witness. The court can permit this until any other witness or witnesses have been examined, or it can recall any witness for further cross-examination. The High Court's ruling meticulously examines the scope and application of this power. It underscores the legislative intent behind this provision, aiming to safeguard fairness. Deferring cross-examination can be a critical strategic tool for the defense. It can prevent prosecution witnesses from altering their testimonies. The High Court acknowledged this legitimate concern. This ensures the truth-seeking process is not compromised. The case that brought this significant legal question to the forefront is titled, "This petition was filed before the High Court of Jammu and Kashmir and Ladakh." The petitioners in this case were individuals accused in a serious criminal matter. They were seeking a specific procedural relief from the higher court. Their plea was directly related to the conduct of their ongoing trial. They believed that a particular order by the trial court was detrimental to their right to a fair defense. The case stems from a murder trial, which has been referred to in media reports as the Greater Kailash murder case. The deceased individual in this case was identified as Avtar Singh. The petitioners were among the 9 individuals accused in connection with his death. One of the accused is reportedly a retired Indian Police Service officer, adding another layer of public interest to the proceedings. The specific request made by the petitioners, Ravinder Kumar and others, was crucial. They sought permission to defer the cross-examination of 6 key prosecution eyewitnesses. The individuals petitioning the High Court faced a battery of serious charges. These accusations were framed under multiple sections of the Indian Penal Code. The charges included Section 120B, which pertains to criminal conspiracy, suggesting a planned criminal act. They were also charged under Section 447 for criminal trespass and Section 427 for mischief causing damage. More gravely, Section 302, the charge for murder, was invoked alongside Section 307 for attempt to murder. Further charges compounded the legal challenges for the petitioners. Section 506 of the IPC, relating to criminal intimidation, was also applied. Section 147 for rioting suggested a tumultuous event involving multiple individuals. Finally, Section 201, which deals with causing the disappearance of evidence of an offence or giving false information to screen an offender, was also part of the charges. This comprehensive list of accusations painted a picture of a complex criminal event. Dissatisfied with the trial court's order, the petitioners, Ravinder Kumar and his co-accused, sought recourse. They filed a petition in the High Court of Jammu and Kashmir and Ladakh. This petition was moved under Section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023. This section provides for the High Court's power of revision. Additionally, they invoked Article 227 of the Constitution of India. Article 227 grants High Courts the power of superintendence over all courts and tribunals within their jurisdiction. This legal pathway allowed the higher court to review the trial court's procedural decision. Advocates Sakal Bhushan and Rahul Sharma represented the petitioners. The matter came before Justice Rajesh Sekhri of the J&K and Ladakh High Court. After careful consideration, Justice Sekhri found the reasoning of the trial court to be flawed. In its deliberations, the J&K High Court also considered relevant precedents. Notably, it referred to the Supreme Court's decision in This Supreme Court case had previously laid down guidelines concerning the deferral of cross-examination. The Apex Court had suggested that applications for deferment should preferably be made before the cross-examination begins. It also stated that the trial court should record reasons in writing if it decides to defer. The Supreme Court's guidance aimed to structure the discretion granted to trial courts under the then existing CrPC provision, which is analogous to Section 254, subsection 3 BNSS. However, Justice Sekhri astutely pointed out a nuance in the Supreme Court's language. The High Court observed that the guidelines in the case use terms like preferably and as far as possible. This phrasing, the J&K High Court interpreted, meant that the Supreme Court's guidelines were suggestive and directory in nature, rather than strictly mandatory or inflexible rules. The ruling by the J&K and Ladakh High Court is more than just a decision in a single case. It carries substantial significance for the broader landscape of criminal jurisprudence in India. It clarifies the procedural aspect of deferring cross-examination under Section 254, subsection 3 of the Bharatiya Nagarik Suraksha Sanhita. Such judicial interpretations are vital for ensuring consistent and fair application of the law. This sets a precedent for similar situations. The judgment reinforces the fundamental principles of a fair trial. It balances the rights of the prosecution with the right of the accused to a robust defense. The High Court's recognition of withholding cross-examination until all key witnesses have testified is crucial. It ensures substantive justice and prevents undue advantage to one side.